2026 Regulatory Updates webinar. Really excited to have everybody join us today. I see all of the attendees numbers increasing. Here is a brief version of our agenda for this afternoon. The full version can be found on our website. We do plan on taking about a 10-minute break around 2:25 today. A lot of content to get through. Really excited and grateful for the speakers and the panelists that we have today. It's taken a lot of effort to pull this together, so we just really appreciate their time. We are going to take questions and closing remarks at the end, but please do feel free to post your questions in the Q&A throughout the presentations today. And if we happen to end up ahead of schedule, we'll try to ask some of those questions of our speakers throughout. Quickly go past that. A couple of housekeeping items. The webinar will be recorded. All of the presentations today will also be available on our webpage. You can use that QR code to find those recordings as well as that agenda I mentioned earlier. Additionally, we have certificates and CEUs available, and those will be provided in the coming days. If you have any questions, feel free to reach out to our email address on the slide here. All right, so first up today, we have Kevin Thomas bringing us the WSSI rule update. Hey, Kevin.
Thank you, Christie. Next slide, please. So before I really start talking about the 2025 WSSI rule, I wanted to just briefly mention a couple of Supreme Court cases that have a direct impact on the current waters of the U.S. and the way it's been written. First one, of course, everyone's heard about is the Sackett versus the EPA. Basically, what that did was the court ruled that the Rapanis plurality decision was correct and that the Kennedy significant nexus was rejected. And thus, at this point, federal jurisdiction has been removed for isolated wetlands. The second one that most folks probably haven't followed as closely is the Lupert Bright case, which ended the Chevron defense doctrine, which is a long-standing doctrine that basically ended it, meaning the courts must use their own independent judgment in deciding if agencies have acted within their statutory authority. And these courts must determine the single best reading of an ambiguous statute. Basically, courts' interpretation remains more stable in the future, which will mean that preventing agencies from shifting rulings abruptly, which means I expect that WSSI from here on going forward, when we have a change in administration, will remain more consistent. Next slide, please. So we know that the 2025 rule was proposed and published in November, and then public comment closed in January the 5th of 2026. Most of us expected the rule to be published by now, and if we had a bet on it in Vegas, we'd have lost a lot of money. So right now there's a lot of uncertainty about when it's going to be published. As of about an hour ago, I checked the White House, their website. EPA has not released it to them yet, so we know that it won't be released probably in the next 30 to 60 days. But what are some of the highlights of the new rule? Obviously, they're going to codify Sackett. Federal jurisdiction is now being removed for isolated wetlands. And one thing I do commend this new administration on is they are trying to define what is a relatively permanent water for the first time in Clean Water Act history. And for WSSI, we have an introduction of the concept of wet season. But if you read the new rule and you follow it closely, you'll see that they had a lot of discussion in there about potentially considering using perennial only to define relatively permanent water, and or the potential to use days of continuous flow as a bright line is also still being considered for potentially defining an RPW. And they did ask for a lot of public comment on that. One thing we know for sure is the use of ordinary high water mark alone is now insufficient to define jurisdiction of what is an RPW. However, with the presentation that was presented with the new rule from EPA and some of the guidance that came out later in April, we do know that ordinary high water mark may be used in like culverts and other things outside of wet season to define potential relatively permanent flow through these features. Exemptions appear codified now, such as farming, silviculture, ranching, ponds, ditches, and some other agricultural runoff. And I'll get into some more of that later on in the presentation. And we know A1 or A13 interstate waters are now eliminated. Next slide, please. So what is a jurisdictional wetland now? It must have a continuous surface connection. It must abut, touch jurisdictional water, and have surface water present at least during the wet season. And there's that term, wet season, and we're going to talk about more of that in just a moment. And what is a relatively permanent water? It are those that are standing or continuously flowing year round, or at least during the wet season. Next slide, please. So the new rule also defines what is a tributary, but more importantly, it defines what is not a tributary. So the new rule defines tributary as a body of water with relatively permanent flow, a bed or bank that connects to a downstream traditional level of water or the territorial seas, either directly through one or more waters or features that convey relatively permanent flow. But what is not a tributary is not a body of water that can contribute surface water flow to a downstream jurisdictional water through a feature such as channelized non-jurisdictional surface water feature, subterranean river, culvert, dam, tunnel, or similar artificial feature, or through a debris pile, boulder-filled wetland, or similar natural feature if that feature does not convey relatively permanent flow. Over here is an example. If this particular water, if this was during the wet season, and we had this culvert hanging the way it is, based on the new rule, everything up reach of this culvert would now be considered non-jurisdictional, no matter what. However, if we were outside of wet season and this culvert happened to have an ordinary high water mark, then there may be some interpretation that this could be a potential continuous surface connection through this culvert, and everything up reach of this would be jurisdictional. Next slide, please. So the EPA is evaluating tools for wet season and how to define an RPW outside of wet season. One tool they are considering and that we've been using since the first Trump administration and it was released for public use is the antecedent precipitation tool. We're now on the third version. And another tool that's implemented within the APT, which is the WebWimp, that many of us have used for decades, that was developed out of University of Delaware to define when we are or not in wet season. Some field tools that they're thinking about using for use is stream duration assessment method and some state flow regimes tools that I'll talk about in just a moment. Next slide, please. So what is the APT? Really, if you've been doing AJDs or jurisdictional submittals for the last since the first Trump administration, these have been part of your data package. And what the APT is if you ever filled out your wetland data form at the very beginning, it asks you, are you in a typical climatic condition? And for decades, many of us spent hours doing database searches, figuring out when we were in the field, we're in a typical climatic condition. Well, this is a one-stop shop. And what it does, it tells us, are we in a 30-year, 30-day rolling normatic climatic condition now, precipitation-wise? And the bar graph underneath tells us kind of what recent rainfall totals are. And you'll see it also implements WebWimp to tell us if we are or are not in the wet season. And I'm going to talk a little bit more about that in just a moment. But what we do know is when we use the APT, it does have a lag, about 48 hours. So if you're in the field, you're waiting 2 or 3 days to figure out whether or not what your climatic conditions were. The EPA is aware of that. And they also are aware of the lag with the WebWimp. And one way we've combated that in the past and currently we're implementing wells, trail cameras, and on-site weather stations to reduce that lag. However, that isn't onerous on the permittee or the applicant that I don't believe the EPA wants for this new rule. So I believe that is part of the holdup with the new rule being released. Next slide. So as you can see with the output from the wetland, it's pretty binary. You either are or you are not in wet season. However, it's based on a month-to-month basis. So you have a 30+ day lag. And so it gives you some uncertainty when you're out there making your field calls, or for a lay person who just wants to know if the feature in their farm field or whatnot is not jurisdictional during this wet season period. So again, a little bit of a gray area there and lag. And I think that is something that we're all accustomed to as practitioners, but with the new rule, they really want a more of a, I believe, a bright line approach. Next slide, please. So again, there are some tools that can be used to define flow regimes outside the wet season that the EPA is looking at. SDAMS is one, and it's new that the federal government has recently released to be used, I believe, in the Southeast. I don't know if they've approved the rest of the country. It has quantitative inputs, but its output is more qualitative, and I do not like to use it. I do prefer more of the state forms that are kind of tried and true. However, they've not been federally approved. But if you've submitted a data package in the past 20 years, you'll know some of more your seasoned project managers with the Corps prefers these and wants these because they're very quantitative output. You have a bright line, a cut number for the flow regime. So again, it's just a data point that you can be used in the outside the wet season to help define these flow regimes. Next slide, please. And some of the proposed exclusions. So the new rule, I mean, we know it's codifying SAGIT, so isolated wetland drought. But one thing, ditches are some of these new proposed exclusions. If you read the new rule and you look at the slideshow that was utilized for the new rule, you'll note that ditches are pretty much all out unless they are a straightened, relatively permanent water. And if you read that PowerPoint, this presentation that came out with the new rule, basically the EPA and the Corps is defaulting to ditches being non-jurisdictional status when evidence is not sufficient to support historical construction conditions. And if you read the guides, unless there is an RPW flowing into a ditch and there's an RPW flowing out of that ditch, most ditches are now out. Waste treatment systems, lagoons, treatment ponds, settling ponds, those are now being excluded under the new rule, especially anything that was constructed prior to 72. We know groundwater is now out as a WOTUS under this new rule, explicitly is being excluded. And prior converted cropland. If you worked in PC land, a lot of people pay a lot of attention to this. I would. Again, it's much like ditches. A lot of default is being to non-jurisdictional versus jurisdictional, especially if it was done prior to 85, the Clean Food Act. And then if it has, there's a lot of nuance there with the laying dormant for at least 5 years or not being used. So please pay close attention to that in the new rule. The grayer ones over here to the right, the pits exemption is one I would recommend, and ponds that have been idle. It's one I had hoped they would put into the new rule that wasn't in there. And I do believe they should have looked at including a stormwater exclusion as well, but was not in this new rule. Next slide, please. And then finally, the questions remain. Will the new rule be, when will the new rule be finalized? Really hate to speculate because I've already lost all my money hedging my bet in the first quarter or second quarter from Vegas. So many do believe it will probably be after the summer into the fall. How will the EPA ultimately define an RPW is my biggest question with this new rule. Again, I commend them for taking this leap at trying to define it. It's not easy, and this is the first administration to try to do that. When will it, what will it ultimately look like? big question there. And finally, for me, RICO 05, ordinary high water mark, out as being able to define federal jurisdiction over these RPWs now. However, culverts and things like that will need to still use that ordinary high water mark guidance outside of the wet season as it's currently defined in the new rule to figure out whether or not it is an RPW. That's it for me. I'll turn it over to Christie. Thank you.
Kevin, if you don't mind jumping back on real quick.
Sure.
I had a quick question for you. First, for those that are listening, this might be the first time ever that Kevin didn't use his full allotted amount of time. So kudos to you. One question for you that I do have from a consultant's perspective, what is the biggest practical day-to-day change when doing a delineation, particularly in states where the state jurisdiction may differ from the feds?
You want me to answer that?
Yeah, I do.
Okay. So, I mean, again, everything I just spoke about was all federal. And so, you know, there's multiple levels here. So when we go out and we do a jurisdictional determination, nowadays, you know, depending on the state you're in, if you're in the Carolinas, you know, basically it's as the feds are. If you go into the state of Virginia, a good bit of this is out the door, right? So the state of Virginia, California, other states I can't speak to that I don't work in particular, but you'll just have to relay that to your client, is that there's going to be, we're going to get concurrence from the feds, but then also in states like Virginia, you're going to have to seek that state concurrence as well. And you may have features on site that do not meet federal regulation, but that will definitely have state regulation over it in jurisdiction.
Right. Yeah, thanks, Kevin. I appreciate that. We may hear more on that from Justin up next. And in Virginia, you know, we do have the state surface water determination, that SSWD, that the state will issue in addition to getting a jurisdictional determination from the Army Corps. Also, just a reminder for the audience, if you do have any questions, please put those in the Q&A. And next up, we have Justin Curtis. Justin, if you can turn your camera on, and there you go, I see you.
Good afternoon, everyone. Sound coming through?
Yep, we got you.
Excellent. And slide showing up? Nope, you're seeing me.
Almost.
All right. There we go. All good.
Perfect.
All right. Thank you, Christie. And like I said, good afternoon, everyone. Justin Curtis with AquaLaw. I don't know why they always invite me to these sort of regulatory discussions, but yeah, unfortunately for you all, you get to hear a lawyer talk for the next 20, 30 minutes or so. So we will do our best. I'll say from experience that, you know, working with, I think what a lot of the folks on this call are, you know, PWDs and professionals and consultants and developers, you know, that collaboration always works best when, you know, I have a good understanding of what it is that you all do, and I do my best. And you all have a reasonable basic understanding of the legal framework and the legal issues that we're dealing with. And then we can sort of meet in the middle and, you know, I think be more effective. So I'm going to cover a couple of the legal issues, but they'll be at a very high level, and hopefully there'll be issues that are relevant to everything that we're doing. So, and then this picture, this just amused me, but, you know, I'll just say when we're talking about judges and talking about lawyers, you should never assume they have any idea what you're talking about. So sometimes we have to keep things real simple. So I will try to keep things real simple, and hopefully we'll have a productive few minutes here. So see, advance the slide, if it will. There we go. Technical glitches this morning. My computer wasn't working, or this afternoon. My computer wasn't working up until about 5 minutes ago, so this was a bit touch and go. All right, so going to start with waters of the United States, and I'm not going to cover what Kevin did, obviously, but we're going to try to flesh out some of the nuances there, some of the other legal issues, and some of the other implications and effects. And I got here. This is my patent pending WOTUS tester, which is usually how the rubber duck test is usually how I describe it to the new WOTUS rule or the forthcoming WOTUS rule to some folks that are non-experts, but it's not perfect, but it's pretty close. All right, going to start with this is for some folks this would be a trip down memory lane, and I'm certainly not going to go through everything on this slide, but so this, I think, at least visually, is a really good just sort of overview of what's been going on with the WOTUS rules since it was the Federal Water Pollution Control Act of 1972 brought it into existence. So over the years, each one of these, and this is not a comprehensive list, but each one of these was a change to the WOTUS rule, either expanding jurisdiction or shrinking jurisdiction, and we have just yo-yoed for the last, what is it now, 50 years, 55 years? Wow. So, we started with, in 1972, with only navigable, in fact, waters. So Section 10 waters were the only things that were regulated under the Clean Water Act. That didn't last very long. And then the Ford administration actually expanded it all the way out to the extent of interstate commerce, which that makes things very, very broad, and that gave birth to, for example, the isolated or the migratory bird rule, excuse me, which on which the Corps and EPA asserted jurisdiction over small isolated ponds on the theory that ducks may land on them, and ducks travel across state lines, and hunting is a commercial activity. So providing ponds for ducks affects interstate commerce, therefore they could regulate it under the Clean Water Act. Of course, the Supreme Court shot that down in the Swan Sea case, and ever since then we've yo-yoed back and forth. So here we are. So the big question is, how do we get into this mess? I think it's important and beneficial and useful to really understand the context of all that's going on. I mean, as practitioners, we need to care about what the final rule is and what it says, but I think to really understand the program, sort of need to go back to the first principles and the roots. So in 1972, Congress in its infinite wisdom wrote what we now have come to know and love as the Clean Water Act. That 1972 law runs roughly 45,000 words, and they only managed to devote roughly, 15 to what's probably one of the most important issues, which is we Congress are going to enact this brand new sweeping set of legislation to regulate and protect waters across the United States. And we're not really going to explain what those are. So here's the definition we got. The term navigable waters, and navigable waters is the term that's actually used in the Clean Water Act, not WOTUS. And navigable waters means the waters of the United States, including the territorial seas. So, I mean, that's one, completely circular, but it really tells us nothing about what Congress intended EPA to regulate and the Corps to regulate. So, as much aggravation as the yo-yoing rules have caused for a lot of folks, it's probably not fair to point the finger at the Corps and EPA for that. I think this really is this more of Congress's issue, because you're trying to construe this, and imagine taking this definition, if this is all you had, and go out in the field and trying to delineate a site, it really doesn't tell you much of anything. So that's where we are, and that's what Congress has left us with. And they haven't touched this since 1972. So notwithstanding all the problems, all the issues, all the litigation, the billions of dollars wasted in new rules and litigation, and they haven't touched it. So now gonna touch on Chevron, and this is where we get into a couple of those legal issues. And I know Kevin referenced Chevron and referenced Loper Bright, but I just want to take that one step further and explain how that is particularly relevant to what we're talking about today, what's going on with the WOTUS rule, and what may happen with the WOTUS rule in the future. So, of course, Chevron is the case that and Chevron only applies to regulations, just by the by, not permits. That's a common misconception. But what Chevron said, in effect, is if a statute is ambiguous and an agency issues regulations to construe it, that courts should defer to the agencies on the interpretation of the statute. That was a black letter law for many, many years. And in the oral argument for the Loper-Bright case, which came out in 2023, here's a quote from Justice Kavanaugh, and I think he hit the nail on the head. He said, Chevron ushers in shocks to the system every 4 or 8 years when a new administration comes in, whether it's communications law, securities law, competition law, or environmental law. And he's right. And the reason is because what Chevron said is, an agency gets deference under their interpretation of the statute, and if their interpretation is an acceptable interpretation of the statute, then the courts will let it stand. So that is how we get this. Because you have agencies, every new administration can come in, and I think we've seen this accelerate in the last 8 years, 8 to 10 years. New agency comes in and they say, well, we are going to interpret the rule differently. We're going to reissue it. And we're going to completely change it. And if our ruling, as long as it's under Chevron, as long as it's a permissible reading of the statute, then courts have to uphold it. So that's how we get the yo-yoing back and forth. And I don't know, I think time will tell whether it was effective or not, but the Supreme Court intended, or the intent at least stated intent was to prevent that and stop it. So we have the Loper-Bright v. Raimondo case that came out in 2024. I have a couple quotes here from the opinion that I think are particularly relevant. And the takeaway here with what the court said is that all statutes have a single best meaning, one and only best meaning. And the court said it doesn't make any sense to talk about a permissible interpretation of a statute if it's not if it's not the best reading of the statute, it is not a permissible reading of the statute. And step further, where if we're talking about statutes, we're talking about the law. And courts are the branch of government who's in charge of interpreting and construing what the law means, not agencies, which are executive branch. So we get to the bottom line here. We get to the rub of the issue, which is if there's questions about statutory interpretation, like the definition of navigable waters, the definition is, or what it means is what the court concludes is the best reading of the word. That's a sweeping change in how we've handled these issues in the past, and I think time will tell how this will be carried over to other cases, or in other examples. But this was a groundswell change, at least potentially. And so then we circle back to Sackett, and we circle back to our WOTUS rule. Now, I do want to flag a couple of things here that are, really unusual, and when you think about it, almost absurd. So what we have with the WOTUS rule, we've got a bunch of concepts, like adjacent wetlands. Adjacent wetlands only appears in the Clean Water Act one time, and it's in 404G, in a section talking about state assumption of the 404 permitting program. Otherwise, adjacent wetlands is not we come to know that term, and we feel we sort of deal with it as a foundational principle of the WOTUS rule, but it really has no grounding, or very little grounding, in the Clean Water Act itself. Relatively permanent body of water, again, that is not in the Clean Water Act. Traditional interstate navigable waters, not really in the Clean Water Act. Continuous surface connection. I'll throw in the significant nexus test from the Rapanos case. These are all judge-made terms and judge-made concepts, and y'all are out in the field doing delineations, relying on language. It's not statutory language, it's judge-made language, it's lawyer language, and it's really kind of an absurd position, an absurd situation that Congress really needs to step in and fix, because it is kind of silly that agencies aren't getting deference on these issues, and therefore we're stuck with effectively judge-made law. So I will say, if there is one bright side to all of this, is because of Loper-Bright and Sackett's, Loper Bright saying the courts get to decide the best reading of the law, and then Sackett, which then saying what the best reading of the navigable waters definition is. In theory, we should have some regulatory certainty for the next, which in my mind has always been the holy grail, some regulatory certainty over the meaning of the WOTUS rule for at least until Congress does something. So, again, time will tell whether or not, subsequent EPAs and Corps can chip away and change and tweak things, but it's going to be really hard for any of the agencies with the cases that have been issued. It's going to be really hard for them to make substantive changes, material changes to the rule that's going to be forthcoming, assuming it's held up by the courts. All right, so now we'll pivot to the states. So where does all this back and forth, the yo-yoing of the WOTUS rule leave states? Well, let me go back again to first principles and talk about what the Clean Water Act actually says about states. And in the Clean Water Act section 101, so right at the beginning, Congress has a whole list of congressional declarations of policies. And one of those policies is that Congress recognizes and intends to preserve and protect the primary responsibility and rights of states to address pollution and to regulate their land and water resources. So in the, this, I know this is stating the obvious, but as federal jurisdiction shrinks in response to Sackett and the forthcoming WOTUS rule, that puts more of the responsibility or burden, however you want to characterize it, on states to protect their land and water resources and their wetlands, provided that is something the state, as a matter of policy, intends to do. So we have had a number of responses to Sackett, and I will say a couple of these examples predate Sackett by a little bit, but I think folks were reading the handwriting on the wall. So it's interesting. We've had states have gone in all different directions as to how they've responded to Sackett. So a number of states, as you would expect, and I think, the states that are, that care about wetlands and have, there is that balance between protecting environmental resources and development. Well, the states that lean more towards, the protecting the environmental resources have stepped in to fill the breach. And we've got a number of states that have either enacted new or expanded stream and wetland permitting programs. Colorado, New York, and Maryland are good examples. And it's interesting, the New York example brought back a memory of mine that I had. During the first Trump administration, I was having a conversation with a lawyer that worked in the New York City environmental and their law department for the environment. And she was lamenting the Trump administration WOTUS rule because New York City's water comes from upstate New York. And at the time, and still, the state only regulated wetland impacts that were 12.4 acres or greater. And she was lamenting that they were going to lose protection of their the filtering effect and the beneficial water quality effect of the resources that would no longer be covered by WOTUS. I said to her, I said, look, I think your problem is not so much in DC, it's in Albany. The states have 100% authority to regulate impacts of streams and wetlands. And if, states like Virginia, which, traditionally has been at least a purple state, if Virginia can get its act together and regulate wetlands, and I'm pretty sure a state like New York should be able to do that. Well, they finally act in 2023. They're reducing those thresholds, and they've got a number of other provisions. Obviously, what the summaries here are just very, single bullet points, but there's more to it. So you have the states that have expanded their regulation. Others have done nothing. And those fall into basically two different categories. Of course, there's states I mentioned like Virginia that already have existing stream and wetland permitting programs that are broader than 404. So in a state like Virginia, the shrinking of WOTUS doesn't have an actual much of a practical effect. It affects how we go about doing things and how we get permits, but it doesn't affect doesn't have a significant effect on what happens on the ground as far as permitting and mitigation, et cetera. You've got other states that had no stream wetland programs before, and they still have no stream wetland programs after. West Virginia is an example of that. And you've actually had a number of states that have reduced their regulation of streams and wetlands in response to WOTUS or other issues. North Carolina is a good example. It was a law passed in 2023 that prohibited the state from regulating non-WSSI wetlands with some caveats. Now that was in response to an action by the governor who was acting to try to protect, increase protection of wetlands, and the legislature reacted and overrode the governor's veto actually to reduce the regulation. Another state, Indiana is another one. Indiana has actually a fairly robust stream wetland program, but they have reduced the regulation of isolated wetlands since SACIT was issued. So I'll go back to where I started in that question. Is there any hope that Congress is going to fix it? The Clean Water Act is genuinely hard to amend. Excuse me. There have been very few substantive amendments to the Clean Water Act over the years. It's so controversial. And I mean, the bottom line is, we talk about the Waters of the United States rule. I sort of watched with interest the debates between the folks when the WOTUS rules of the Biden WOTUS rules and the first Trump administration WOTUS rules were out there. And these questions, you had on one side, well, we need to follow the science. And on the other side, we need to, stop government overreach. There were nuances there, but I think those were the two main camps. And I really, my personal opinion was, I think they're both kind of missing the point. I mean, it ultimately is a policy decision. What we need is Congress or the states at the state level to make a policy decision what streams and wetland resources are worth protecting. And then we can all figure out what the WOTUS rule or the state waters rule should be. But unfortunately, we don't agree on the policy, and that's sort of how we got here. But when we talk about amending the Clean Water Act, I thought this was, at least for me, an amusing example. But in the Declaration of Policy section in the Clean Water Act, there's actually a statement that is Congress's goal. In 1972, I can just imagine the naivete in this, but they wanted to eliminate the discharge of pollutants into navigable waters by 1985. So we are now, 40 years behind schedule. That's the only Clean Water Act that hasn't changed, and that's still the goal. So be it. Last slide on WOTUS. I do want to just flag there are other implications of the WOTUS rule, and this is just a partial list. There's a lot more going on here, but from a permitting perspective, I think it's worth flagging, especially including in states where we have state stream and wetland programs, permitting programs. There's a lot that comes along with federal jurisdiction over streams and wetlands. We bring in the Endangered Species Act, the National Historic Preservation Act. So, shrinking of WOTUS doesn't only affect the protection of stream and wetland, regulation of stream and wetland. It also affects some species regulation, historical resources regulations as well. 401 certification, 401 certification, we're going to talk about that a little bit more in a minute, but that's triggered when a federal agency action or an applicant for a federal permit or license, where it has a project that will result in a discharge to WOTUS. And, as WOTUS shrinks, then you potentially have fewer projects subject to 401 certification. SPCC plans are triggered by potential releases to waters. Shrinking WOTUS, at least theoretically, shrinks that. You lose an EPA and Army Corps enforcement with shrinking WOTUS. Regulation of discharges. I know that's not necessarily particularly germane to this particular topic, but I think it's important to note. There's all of these questions. The Clean Water Act prohibits an unpermitted discharge to a stream, whether that's fill or pollutants. And if a bunch of waters are no longer WOTUS, then are discharges to those streams now permissible? Again, depending on state law. States issue water quality standards must issue water quality standards for WOTUS, and again, states can expand that. But the WOTUS rule potentially shrinks the universe of streams that are protected under 402 as well. With one caveat, and I do just want to put a reminder out there for folks that are aware, there was another case that came out. We're talking about shrinking federal jurisdiction. Maui may be, if there's a way to expand it back without changing the statute, it may be through Maui. Maui, in short, was a case, the court established the principle that they would regulate not only direct discharges to waters of the United States, but also indirect discharges that are the functional equivalent of a direct discharge. So in that case, you actually had a UIC permit, an underground injection permit, and wastewater being pumped in the ground, and it just popped out under the water in the Pacific. And the court said, even though you're not discharging directly to the Pacific, it's a functional equivalent of a discharge, so you're now regulated. And this principle has been brought up in a number of different contexts where you've got a discharge or pollutants going into water, going into groundwater, being spilled on the ground, popping up in a stream or wetland somewhere. And that's another, potential federal regulatory hook. So I did just want to flag that for folks. All right, moving on to Clean Water Act 401 or water quality certification under Clean Water Act 401. We'll touch upon this one briefly. This is a pretty high, I guess you could say perhaps a bit of a controversial rule in recent years. The intent of the Clean Water Act is to protect, protect water resources, but also to preserve states' authority over water quantity and over water quality. And states preserve their water quality through issuing water quality standards and when federal agencies are involved, 401. So what 401 does in a nutshell, for those that aren't aware or familiar, when you've got that federal agency action or a federal permit application, the state can review the application or action, and then they can either issue certification, in which case the permit or action can go through, or they can deny, in which case it can't, or they can condition it. And if they condition it, any conditions that the state imposes on the activity automatically by law become conditions of the federal permit or license. So here we go. All right, I'll get to that in a sec. So this rule, like the WOTUS rule, has bounced around for years. And we have the reason why we're talking about it now is because we have another pending rulemaking coming. I did want to flag something else that I thought was somewhat amusing. There are a lot of, for folks that are familiar with 401, we, sort of talk oftentimes about reasonable assurance. The state would make it a finding that has reasonable assurance that water quality will be protected. Well, reasonable assurance, actually, that language isn't in the statute. That was in the prior version of the statute that was from the 1960s. And EPA issued the 401 rule, the one that we used all the way up until 2020 in 1971. So that rule actually predated the Clean Water Act and included language from the pre-Clean Water Act regime. And there was a notice of proposed rulemaking in 1979 where EPA said that they needed to change and update this rule because it doesn't reflect the statute. And they didn't get around to it for another 40 years. But here we are. Now we're after waiting 40 plus years to do anything, we're having a flurry of multiple changes in a few years. So why is 401 certification controversial? Well, there are a lot of unanswered questions in the statute and how the program works. There are questions, just procedural questions. How do you request 401 certification? What information needs to be submitted? The new rules are trying to sorry if I can see that I've got, I don't know why that's there on the screen. Okay. New rules are trying to bring some clarity to that. The timeline has always been a question in 401 certification issues. So the statute says from the time you request certification to the time the state, and 401s can be issued, they're typically issued by states, but can be issued by EPA or by tribes in some cases. It can be no more than 1 year. That is the maximum amount of time a state can consider a 401 certification request. Although the federal agencies, depending on how you read the statute, have authority to reduce that 1 year time period. How do you start the clock for that 1 year time period? If a state misses the 1 year time period and doesn't act, then they've waived their right to issue a 401 certification. There's also a lot of questions about resetting the clock, because historically you've had a lot of examples where the state says you either withdraw your application and resubmit so that we don't hit the 1 year clock and waive, or we're just going to deny. And some of the rules have attempted to eliminate that process. So those are actually the simple issues. The more the tougher issues that are really the issues that are driving some of the changes to the rule now are, what is the scope of the certification? There are some states and some groups that view 401 certification as effectively a veto over federal actions and a veto over federal permits. That's particularly important in certain types of projects, particularly those that are subject to federal preemption. So like interstate natural gas pipelines, railroads, hydroelectric dams, those, and there are plenty of others. When a federal agency issues approval for those kinds of projects, most of the state requirements like local land use and zoning laws, et cetera, are all preempted. So the state's one shot to impose conditions or potentially veto or stop a project is through Clean Water Act 401 or CZMA or the Clean Air Act. Those are the other two, and depending on the situation. But so there have been a number of states that have blocked a number of projects that were otherwise subject to federal preemption through 401 certification. So that's one issue. What is the scope of it? Can the state consider non-water quality based impacts? Can they consider climate change? What kind of a discharge triggers the need for a 401 certification? Point source, non-point source? And many questions that are unanswered for 50 years about whether the state can revoke a 401 cert after it was issued. Can they amend it? Do they have an ongoing role? So these are all questions that have lingered for the better part of 50 years. So this slide includes just a quick summary and an overview of the current rule, which is from 2023, the one that's in place now, and the proposed rule. So these are the key differences. This slide does not include every element of the rule. This is just focusing on the differences. So in the key differences, so the first issue that's a distinction between the 2023 rule and the proposed, again, this is not final, it was proposed in January, and that is, does 401 cert apply to point source discharges or non-point source discharges? So point source discharges are what comes out of a pipe, what comes out of a ditch, etc. Non-point sources are things like runoff, sheet flow, things that don't come out of a discrete conveyance. And so, and you can imagine that in the universe of potential discharges, if 401 certification is triggered by discharges, non-point source discharges, sheet flow, and just runoff, that's a huge universe of types of activities and projects. So that's a material change. The application requirements. Currently, the 2023 rule allows a state to add any other requirements they want. So in Virginia, for example, to get 401 certification, you would apply for Virginia Water Protection Permit and follow the application requirements for that. The proposed rule would eliminate that, and so it would have a defined list of requirements and not allow the state to add its own. However, it includes a caveat, at least in the preamble, that says, well, of course, the state can always ask for more information when the request is filed. And the reason why that matters is you have a complete application to trigger that 1 year clock, that reasonable period of time clock. And as long as the information listed in the rule was provided, the clock starts. So that was at least the stated intent for that change. The reasonable period of time. So both the 2023 rule and 2026 rule set 6 months as a default period for the state to issue 401 certification from they request until they act, either grant, deny, or waive. 2023 rule allows that 6 month period to be extended if the agency and the state, or EPA or tribe, the agency and the state agree to extend it. Again, no more than 1 year, so up to 1 year. Big change. So the proposed rule is to extend 6 months to up to a year in agreement of the agency, the state, and the applicant. So that would give applicants a role in effectively a veto over extensions of the reasonable period of time. Another issue that's different, the scope of certification, and this is a one-word difference, but it actually has a pretty significant effect, and that's whether we're certifying the activity or the discharge, because that affects the scope of the review and the scope of the conditions. And then lastly, a modification process similar to the reasonable period of time. The proposed rule would require the applicant's consent to modify a 401 cert after it was issued. I will add that both the 2023 rule and the 2026 rule prevent a state from revoking a 401 certification after it's been issued, but they can modify it with agreement. All right, we are going to move on from 401 certification and just spend a couple minutes on relevant executive orders that are relevant to the work I think many of us do. And this has been, as most things have been recently, this has been pretty interesting. I'm sorry, I don't have pictures here. I put the slides together last night and this morning, and I ran out of gas. So the first one is EO 14156, declaring a national energy emergency. For this EO, the president actually declared an emergency for insufficient energy production, transportation, generation, etc. There's a National Emergencies Act, and the Emergencies Act doesn't give the president more power to do anything, but multiple other agencies throughout the federal government have congressionally approved of statutes that say when an emergency is declared, you can do X, Y, and Z. So declaring an energy emergency opens up some of those emergency procedures. And what this executive order does, among other things, it directs federal agencies to use those emergency authorities to identify and expedite energy projects. It also has a whole long section on the Corps, directs the Corps to designate certain projects for emergency treatment and then exercise its emergency permit processing procedures, but also expedites Endangered Species Act review. We have EO 14260, protecting American energy from state overreach. I think you'll see a theme here with the 401 cert rule, where you need the state and the agency can't just make decisions on certain things. You need the applicant to consent as well. Here, similar process. This executive order is actually pretty, well, they're all pretty unprecedented, but it directs the Attorney General to go into a review of state and local laws, policies, practices, and causes of action, so cases that have been filed by states, determine which of those state actions or local actions burden energy development, and when it identifies, if it identifies those, directs the Attorney General to take legal action to stop the quote-unquote illegal, the enforcement of those illegal laws, or, and this is interesting, continuation of civil action. So the way executive order is written, if you've got a state, say, suing EPA, if the Attorney General, for whatever reason, deems that unlawful, illegal, and contrary to this executive order, the Attorney General would have instructions to stop that case somehow. But interesting times we live in. Data centers. Data centers have their own executive order that was issued about 12 months ago. I'm sorry, 10, 11, 12 months ago. It includes a number of conditions that are meant to facilitate data center development, including identifying or directing agencies to identify CADXs, categorical exclusions from NEPA that they can use to expedite data center permitting. It makes certain data center adjacent projects like energy development and manufacturing eligible for Fast 41, and I should say Fast 41, not Fast 401. Fast 41 treatment, which is an expedited federal permitting process. So also, I think this one's interesting too, and we'll see where this lands, but the executive order orders EPA to evaluate and modify its regulations under the Clean Water Act, Clean Air Act, CERCLA, TSCA, and others, to the extent EPA deems necessary to facilitate data centers. It also directs the Corps to determine if a new nationwide permit should be issued for data centers. I haven't seen anything about action on that. However, in the latest round of nationwides, there is new language in Nationwide 39 that clarifies that that nationwide permit, which applies to commercial activities, includes data centers. Just a handful of other relevant executive orders. I won't go through all of these. I'll just flag one, and that's the Unleashing Prosperity Through Deregulation. This one always amuses me. that the directive is for every one new regulation agency issues, it needs to repeal 10. I think most of us that live in this world know how silly that is. Sometimes you fix issues by issuing regulations like, I don't know, like general permitting regulations. So it's not always the best way to reduce burden by deleting 10 arbitrary regs. And how do you define a reg? I don't know. Is that sections? Is that, codes of the code of, or, chapters of the Code of Federal Regulation? I don't know what a regulation is, and that's certainly not defined there. So last slide, and then I'll hand it back to Christie. Just one note of caution about these the executive orders. In some respects, they can be a trap, and in particularly, there are plenty of cases out there, plenty of examples out there. We've seen all the litigation, the high-profile litigation over big projects, Keystone XL, Dakota Access Pipeline, Pebble Mine, etc. That cases get challenged, or permits get challenged increasingly these days. And, there is a risk when you take advantage of one of those executive orders to expedite things. There is always a risk that a court could view that dimly and increase your litigation risk. So there is some balancing to be done there. So it's not, they expedite projects on one hand, but also, just need to be cognizant and careful of potential risks that could be created. And with that, thank you for all your time. I will hand it back to Christie.
Thank you, Justin. Appreciate that note. That was a good point as well. And always appreciate the graphics that you have in your slides. Next up, we have Kim Prisco-Baggett, Acting Norfolk District Chief. Kim, I'll let you get your slides teed up. As you're doing that, I did just want to note, I see we have a question from Sarah in the chat. We'll try to capture that either during Kim's presentation or at the end with the Q&A. I also just got a note from the green room that I think some folks are having trouble with the Q&A. So if for some reason you're not able to submit your question through the Q&A tab, you can send it to the webinars@wetlands.com email address, and then we can filter that question into the session today. Kim, were you able to get your slides up?
Give me just 1 second. I'm gonna switch screens here. Is that not sharing? Oh, there we go. Okay.
Oh, thanks.
Trying to go full screen mode, but it's being slow. Yes.
Tap F5. F5 will do it for you. Or not today. Usually works on my computer. It's okay. We really want to hear what you have to say, though.
There we go.
There we go.
Yep. Okay, we're good now. Okay, so good afternoon, everybody. I am Kim Prisco-Baggett. I am the acting chief of the Norfolk District Regulatory Program. And I'm just going to give you a few updates on some current happenings in our program. Oops. There we go. Okay, so we're going to start with the 2026 nationwide permits. I'm sure most of you are aware that these were published and made effective back in March. So we reissued 56 of our existing nationwide permits. We had one permit, it's nationwide 56, that was not reissued. And we issued one new permit, which is nationwide 60, for activities to improve fish passage. And so just for your kind of situational awareness, here's some information on the new one. Big point here is that it's got a limit of 1 acre, and a pre-construction notification is required if the loss is greater than 1/10 of an acre. Grandfather process for those permits is the same as they have always been. So if as of March 14th, the project that was certified under the 2021 nationwide permits is either under contract or has commenced construction, then you have an extra year to take those impacts. If the work was not started or not under contract by March 14th, then you will need to get a new verification under the 2026 nationwide permits. I'm going to talk a little later about RRS, and that's generally the preferred way we like to get requests. But in this case, if you are looking for re-verification under the 2026 nationwide permits and nothing has changed in your proposal, all we need is a quick email saying that you would like to do that. There are no changes, and you can send that to our RegRod box. So along with those nationwide permits, we always have our regional conditions, and there were a few changes to those this time around. We did add a couple of points. So for nationwide 6 for seismic surveying activities, a PCN is required. PCN is also required if the proposed activities are in a habitat area of particular concern under the EFH program. And then we also added under Nationwide 18, this is when we have multiple impacts proposed in a subdivision, multiple lots, same applicant. In that case, we are indicating that the threshold would apply to all of the impacts by that applicant. So for example, if you're proposing one builder is building 3 lots within the same subdivision, and they need nationwide 18s to build a culvert crossing, then those would be looked at cumulatively under the nationwide 18. Then we went ahead and removed a couple of regional conditions to try to simplify things. One that we removed was the trout waters regional condition, which has been there forever. And then we also removed the checklist requirement for the nationwide 27, and that's because under the new nationwide 27, there is no pre-construction notification, so we just don't need that checklist any longer. And then we did, as always, when we do a reissuance, we have to go back through CZMA and 401 water quality certification. So there were some changes for that. This time around, we did get full general concurrence on both of those. And so through that, we were able to remove some regional conditions, such as the one that required DWR coordination for state species. That regional condition has been removed. And then this time around, we did get general concurrence on 401 water quality certification for all of them, except for nationwide 32, in which case DEQ waived. So for those nationwide permits now, you won't need to get individual certification. Okay, so the new one that I'm kind of announcing today, because it actually was just published on our website today, is we have updated the regional condition 4 for endangered species. So keeps trying to jump ahead on me. So for this one, this is a little bit of kind of background on how that regional condition has changed. In the 2021 cycle, we had some wording in there that indicated that even if a species is listed on your official species list, if you as an applicant or agent determine that there is no impact to that species, you do not need to submit a pre-construction notification. And that had been in place for a couple of nationwide cycles. Well, this time around, we had a little concern from our Office of Counsel, and they didn't feel comfortable stating that. So we went to try to remove that condition. Unfortunately, we only removed a portion of it, and that actually caused some additional confusion. So you'll see the verbiage there from 2026. We kept the beginning and removed the part that says, unless the project does not impact a species. We should have removed the whole sentence. So this upcoming revision that was just published today now just removes that entire sentence and says that the applicant can use IPAC to determine if a species may be affected. And then I just noted on here, we always have our general condition 18 too. This is the reason our council was a little concerned about the wording. It talks about a PCN's required if a species is in the vicinity. And so, you know, per regulation, technically a federal agency is the only one that can really make an effect determination. So if you are under any, you know, concern on whether a species could or could not be affected, then we would just recommend that you go ahead and submit a pre-construction notification. And like I said, that is out published today. It's on our website. All the enclosures have been updated with that new regional condition as well. Okay, and so I think one of the previous speakers, maybe Justin, had mentioned the nationwide permits round 2. Just when we thought we were done, we have to do it all over again. So there was a Federal Register notice, and basically it didn't really propose anything. It was just looking for public comment on what the new round of nationwide permits should look like, whether that be changes to types of activities covered, changes in thresholds. They just wanted to get all sorts of ideas and go from there. So that Federal Register notice soliciting comments did close on 15 May. Headquarters is currently reviewing all those comments they've received. They're going to determine a path forward. But in general, the intent of this effort is to just further streamline and add efficiencies to our general permit program. So more to come on that one. An update on our SPGP, State Programmatic General Permit. So this one, our residential, commercial, industrial, and recreational development and linear transportation SPGPs both expire as of August 1st. We are currently working on the 2026 SPGP, but we anticipate that it should be effective by August 2nd, so there should be no gap in coverage. And then these bullet points below are largely the bullet points that we included in our public notice back in September 2025. And it's looking like this is kind of the anticipated direction of what that final SPGP will look like. So we are going to increase the thresholds. So RCIR will go up to 2 acres of impacts, and linear transportation will be up to 1 acre of impacts. We had kind of thrown out there whether the preliminary screening form was really a necessary component. And we got different answers back depending on the region of the state, largely. So what we've decided to do is go ahead and retain that as an optional process. And then we've done some kind of cleaning up and combining of lists and definitions. We have done a lot to make the SPGP align and look and format with the nationwide permit. So if you're used to seeing those nationwide permanent enclosures, this will look very similar. And then just some minor editorial changes. So largely what we proposed in the public notice is what you will see come August. And then the grandfathering for that will be the same as, will be the same as with the nationwide permits, where if you are under contract or have commenced work by the expiration date of August 1st, and you can complete the work in a year, you'll have that time under the 2022 SPGPs to complete the work and won't need to re-verify. Okay, so you all may have heard the Assistant Secretary of the Army for Civil Works has started this initiative called Building Infrastructure, Not Paperwork, largely looking at efforts to streamline and build efficiencies in our program. And so some of the ways that we're doing that, I mentioned RRS earlier. Hopefully everybody here is familiar with that and has been using that system to submit your requests here in Virginia. We are still maintaining that as the kind of official joint permit application process. RRS has really been a very helpful system in that it allows us to get projects assigned to our project managers more quickly. We don't have to do a bunch of data entry on our end. We receive it, and pretty much same day it goes to a project manager. In addition, we have some modules that users can use to get decisions immediately out of the system instead of having to wait for a project manager. So we've got a no permit required module. That is only if no permit's required on an activity basis. If you're looking for a no permit required letter for geographic jurisdiction, you will still have to submit for that, and we will have to look at it and get a response back to you. But if really you're saying no permit's required based on the activity that's proposed, there is a nice module in there. You run through the questions. If you meet all the criteria, you immediately get a letter certifying no permit required. And then most recently, I think this has only been out maybe a week or two now, we have a no PCN required module. So this is in cases where for our nationwide permits, often there's some sort of threshold for submitting a pre-construction notification. If you're under that threshold and meet all the conditions of the permit, then you can go ahead and start work without anything in writing from the Corps. A lot of people do like having something in writing though. And so this module allows you to go through, answer questions, certify that you are below that reporting threshold, and then it will provide you a written letter at the end stating that no permit, no PCN is required for that project and you can go to work. We're also looking at our permitting to try to add some streamlining and efficiencies there. So I mentioned the SPGP and the thresholds increasing on that. So that will mean less individual permit reviews. And then once we're done with the SPGP re-verification, we're going to be revising our PASDO. That's going to expire next year. And as part of that re-verification, we're going to revise it so that it looks very similar to the SPGP, where the only thing that the Corps of Engineers will be doing is that federal consultation to completely remove unnecessary duplication between the agencies. Our mitigation team, so we lost 2/3 of our team last year, and have been working to kind of rebuild and reestablish that team. And we're now, we are now there. And they are continuing to work on adding some efficiencies, additional templates, processes, stacking steps that can be done concurrently to shorten the process. And so they're working very hard on those mitigation banks, trying to get them approved more quickly and credits released more quickly. We're looking internally at reducing unnecessary and duplicative project manager tasks, front-loading the initial screening of projects. So our project managers, their goal is within 15 days of receiving a project in their pending list to go and do all of the initial completeness review, screening, and start consultations at that point. We're using technology to the greatest extent possible. So we've got a template generator that is part of our, or connects to our database. So we're not having to enter the same data multiple times. It will pull that information from the database where it can. And then we're also using AI to summarize comments from public notice responses. And then last but not least, we're working with our partners at the VDEQ to develop an MOA that ensures that our agencies are both very quickly looking at JD requests as they come through, you know, whether that's an SSWD or a JD request, and making sure that we're kind of aligned on a path forward on those requests when they first come in. So a lot of work going on, trying to get better and quicker and get responses out the door more quickly. Okay, and one last slide, regulatory request system. I mentioned this a little earlier. Generally, this is the preferred method of submitting your requests here in Virginia. There are a couple of exceptions to that. I think Brenda later will talk about some things that DEQ wants directly to them submitted. But the RRS is not completely built out yet. And so there's a couple of things such as re-verification for general permits when there's no change from the initial proposal, or modifications of individual permits. There's no real pathway for doing that in RRS. And so if you are submitting one of those types of requests, you can just go ahead and send those through our RegRod email. That will be the quickest way. And then we can pull from the documentation we already have. RRS, when you submit a project through it, there is a pathway for our project manager to ask for additional information through RRS. If the original project was not submitted through RRS and we ask for additional information, that will also need to be submitted through email. We have been working with the state. They had a data needs document. It was a fillable PDF document, and we are in the process of incorporating that into data fields within RRS. And so again, that will allow us to incorporate information in our database more quickly, more easily, and share that data with the state as well. That data sharing capacity is the next step on our development task list, so that we can very quickly get that information over to our state agencies. The development team is always working on new modules and upgrades, so you can go into RS one day and go in the next day and things will look a little different, and they're constantly working on making it better. And so bottom line is we urge you to use RRS. It really is a time saver for everybody. If you have any questions about the process or run into any hiccups, please do feel free to contact any of us here at the Corps. We're more than willing to do a Teams call to sit down and kind of walk you through that process. Okay, and then just lastly, a little bit of a heads up that we have recently gone through a bit of a reorganization. This actually should be a little bit easier for the public. What we have done is instead of having 4 geographic sections, we have reduced that to 2. This is largely due to reduction in funding and therefore staffing, and so it just makes sense to kind of reorganize into less sections. And so you'll see this map here. We've broken up the state into the northern branch and then the southern branch. There's also an org chart here with how our project managers are being realigned into there. If you have a pending project with us right now, there will be no change in your project manager. But as new projects come in, they will be assigned to the northern branch and the southern branch. And if you have any questions on how to contact us, our webpage is on there with our contact information, that county breakdown as well. And that is all I have. So thank you very much.
Awesome. Thank you, Kim. Appreciate that. And again, just a reminder that all these slides will also be available on our website, so you can get that contact information as well. And I'm happy to see we're getting questions coming through, so that's great. We'll hit those at the end. Next up, we have Brenda Wynn from Virginia Department of Environmental Quality, the Manager of Office in Wetlands and Stream Protection. Hey, Brenda, how's it going?
Going very fine, thank you. Good afternoon, everyone. I'm Brenda Wynn with the Office of Wetlands and Stream Protection at the Virginia Department of Environmental Quality, and I'm just going to do some brief updates on some main things that have been going on at our agency. And figure out how to, there we go. As many of you know, we have general permits that are issued through our program, the Virginia Water Protection Permit Program. And all 4 of those general permits are expiring on August 1st, 2026. And those general permits are in regulation. We do issue coverages under those general permits, which are also all expiring on August 1st. We did regulatory action that finalized in January, and those will be updated in the Virginia Administrative Code website on the effective date. So the reissued regulations just aren't in there yet. But if you need any information on that, I can provide it, or someone on our staff can certainly access that. There were no significant changes to our GPs. A lot of wordsmithing changes and reorganization just to make things more clear. Kim mentioned we did provide unconditional Section 401 water quality certification on the nationwide permits that were reissued, which allows us to not have a VWP action in many cases under those nationwide permits that were issued. You may get drawn back to us in certain cases. They're listed here, basically activities that are not completed under the former nationwides by March 27th. That was the grandfathering provision that Kim mentioned in her presentation. If activities just simply aren't regulated under the nationwide permits, obviously we have a broader scope than the federal, the Corps of Engineers. So we may have to be involved with something if it is not regulated under a nationwide permit. Activities that typically require an IP, there's a few things like natural gas pipelines of certain sizes that require an individual permit and upland cert from us. Another example is an approved jurisdictional determination. If you use that, that's obviously limiting the scope of waters to federal only. So we have other waters that might be involved on the project that would require us to potentially take an action. There's a lot more information listed on our wetlands webpage, which is provided here, the link and the QR code. We have tried very hard to try to get a lot of information packed into the frequently asked questions and some other documentation that's been updated periodically on there. And we will continue to update those if as necessary as questions come. So please check that out. We also provided unconditional certification to the 2026 state general programmatic general permits that are going to be issued or effective on August 2nd. Activities covered under the SPGPs do require a VWP action, just like they did under the 2022 SPGPs. So existing SPGP permittees need to continue their coverage under our general permits, if they had one to begin with, and they want to continue working after August 1st. We rolled out a notification system. It's a checklist, basically a one and a half page document. You complete some questions and attach some documents. And if you have to pay a fee, you pay the fee, and we will provide you with a coverage effective August 2nd. So effectively, you're working under your existing coverage until through August 1st, and then you pick up with the new coverage on August 2nd. We're asking you to get those notifications back to us by June 18th, so that we can make sure we have enough time to process that before expiration. Again, I've put a QR code here and a link to our webpage that has a lot of useful information, including a frequently asked questions list specific to SPGPs. There's also new flow charts. DEQ and the Corps worked together to produce, and they are posted on the Wetlands webpage as well. And it'll walk you through how to transition from the 22 SPGP to the 26 SPGP, and then how to apply for the new 2026 SPGP verifications. Okay, and then I will also just briefly mention that the agency is currently developing several technology projects that are ongoing that are going to be agency-wide and help our permitting programs across DEQ be more efficient, including the Virginia Water Protection Permit Program. And we're also looking at further regulatory and policy developments that can improve efficiency in our permitting. So please stay tuned to the DEQ News website for upcoming developments and updates on those things. And that's all I have today. Appreciate your time.
Brenda, a quick question for you since we have a couple of minutes. I know that it's DEQ's preference or recommendation with regard to the VWP renewals to get those in by mid-June. Any issue with folks submitting those renewals in July?
The closer it gets to August 1st, the less time we have. So
Sure.
That's why we're just saying, I mean, there's nothing necessarily preventing,
Okay.
but workload as it is, we can't guarantee that we'll be able to get to every single one, especially if there's a last minute rush of, tens, hundreds, whatever.
Sure. I guess in that case, if you guys kind of have a log jam of a bunch of submissions, renewals at the end, do you get to a point where will they be renewed, or do you get to a point where somebody has to submit a brand new application?
We're going to try to prevent the brand new application situation, but what the risk is for the applicants are you're going to have a gap. If it's August 2nd, but you don't get your checklist in on time, and we can't get to it until after the 2nd, then you could potentially have days where there's no coverage.
Right. Okay. Understood. So get your renewals submitted as soon as possible.
Please.
Okay. Awesome. Thank you, Brenda.
You're very welcome.
All right, great. Well, we're a couple minutes early, but I think let's go ahead and take our break. Let me make sure I share our break slide here so everybody knows. We'll take a 10-minute break and then rejoin. We have a lot more information to convey to everybody, mitigation updates, environmental justice. We have a regional roundtable to hit some regulatory updates at a national scale. So please go get your coffee, use the restroom. We'll see you in a few minutes. Thanks all. All right. You guys still hear me okay? Yes. All right. Welcome back. Next up, we have David Locke from our Davey mitigation team to give us a mitigation state of the market update. Hey, David.
Awesome. Hey, Christie. Thank you. Great to be here. appreciate a carve out for mitigation. For a little bit of background, Davey Mitigation is a division of Davey Resource Group. We're focused specifically on that mitigation side and on ecological restoration projects. So just a level set for the uninitiated on compensatory mitigation, established really meaningfully under the compensatory mitigation rule in 2008. Under that rule, permittees are required to avoid jurisdictional waters to the extent possible, minimize those remaining impacts, and then mitigate for what's left. There's an established hierarchy on how you go about mitigating those unavoidable impacts, and that starts with bank credits if they're available in your watershed. If not, go through the in lieu fee if there is one in that watershed or state. And then lastly, the third stated preference is on-site or off-site permittee responsible mitigation. There's a bit of gray area in how that's implemented, and there are certainly times where you can get better ecological outcomes by bucking that hierarchy. Similarly, just because there is an in lieu fee does not always mean it is a really great functioning one or one that is viewed very trustworthy by the regulators. And so we've seen failed in lieu fees in the past. And so ensuring that they are well run is pretty imperative for maximizing those ecological outcomes. So next, going to talk a little bit about some of the changes in the regulatory landscape. And I'll go after that into a little bit on some of the high level trends we're seeing nationally, and then wrap with a little bit of Virginia focus that we're seeing. So broadly, a lot of the impacts to how we're seeing mitigation implemented really ties back to Sackett and what is deemed jurisdictional. And so kind of the overarching message that we're finding is that changes at the federal level is just creating what was already a fairly dislocated process from state to state is making it more so. And the ways that states are either choosing to implement that new take on WOTUS or, as you'll see on the next slide, directly addressing those jurisdictions and how permitting is handled, we're just seeing a lot more variation state to state. Sorry, Christie, just wanted to touch on a couple more things on that last slide. So the recent shifts we're seeing in development trends are really impacting mitigation availability. And so whether it's on population patterns and residential development, where we've seen it's been a long-standing trend of more movement towards the Sun Belt. More recently, we're seeing more residential development and commercial development impacts closer to the Midwest and Great Lakes. All of that is driving changes in mitigation credit availability and thereby how we think about it. Data centers are obviously a big part of the economy these days. Mitigation is no different. So that map you see to the right, that is a map of Columbus, Ohio. There are 48 proposed data center projects just in that small extent that you see there. That's having pretty dramatic impacts on how you can handle mitigation and what's available, and similarly how regulators are viewing approaches to mitigation. So evergreen statement, but I think it applies now more than ever. Identifying your mitigation solution early in the process is crucial, and especially just because you see credits on rivets does not necessarily mean that they're there. They can be reserved. There have been, rivets is definitely prone to record keeping issues. So consulting early on and trying to identify solutions is going to be pretty crucial for staying on time and potentially realizing cost savings. So moving over to some of that state level legislation that I mentioned on the next slide, here is just a map of some of the bills that we've been tracking that have been pretty meaningful. And I know Justin touched on some of these during his section, but specifically as it pertains to mitigation, you can see in the dark red are these bills that have passed the state level. The hatched ones in Illinois and Michigan are proposed. You can kind of track how they are addressing jurisdiction and mitigation by the state's politics generally. So a couple that I've called out that are pretty indicative of some of these trends. Indiana and Tennessee have limited jurisdiction of isolated wetlands in an effort to streamline permits. We have yet to see meaningful change in implementation in those states, but just something to keep an eye on as they've kind of rolled back some of those regulations. In states like Virginia and to a greater extent Colorado as kind of the poster child of this, they are really backstopping what were pre-SACIT rules on jurisdictional waters and making sure that there is still pretty rigorous mitigation requirement. Regardless of which direction the policy and these bills go, in the near term, it is certainly creating hiccups as they're trying to figure out exactly how these are being implemented and how they apply to mitigation. But these are just some states where those changes are actively occurring. The one in Virginia, for those that aren't aware, will also be taking another look at tidal impacts, and that report will be due around this time, I think next summer in 2027, where we'll have a little bit more direction on how some of those impacts will be addressed. So looking at some of the trends that I kind of started getting into earlier, here's a map of, again, on a national basis where data center development is trending. And so again, to harken back to that, where we're seeing more of that demand is where there's going to be much more volatile mitigation supply generally, and where it's pretty crucial to be thinking about it. There's been a lot of talk about Texas becoming a new data center haven. Virginia is still the center of the universe, even when it comes to proposed projects. So from this data source, we tracked about 270 projects that have been proposed in Virginia compared to 70 or so in Texas. Obviously in Texas, living up to their culture, they're much bigger projects. But in terms of just count, we're still seeing more in Virginia. Some of the other just kind of high level trends that we're seeing, Georgia came in third in proposed projects. And then beyond that, Great Lakes and Rust Belt have really started to see more and more traction on new projects, and particularly as power availability is ramping up, that's where we're seeing more and more of that demand as well. So again, just something to keep an eye on and be cognizant of as you're thinking about securing mitigation, whether it's for a data center project or anything else where there's high data center activity. Thinking broadly beyond data centers and just looking where we're seeing some of those trends I described. So take a step back. Generally, in my work tracking these markets, we're kind of thinking at the watershed level, and so this was, I think, my first time looking at a statewide level. So some interesting findings, some expected findings, but took a look at where we've seen increasing demand for wetland credits and stream credits over the last 3 years, and this is what we come back with. So on the wetland side, a lot of activity in the south. Continuing to see, I think, some of those indicators of, again, some of that population movement heading to the south, but also Georgia and Texas are certainly on this list, in part because of the data center development. On the stream side, we're seeing more activity in some of those Midwest states in Ohio and Illinois, and both Arkansas and Alabama, interestingly, were the two states that had increasing demand for both stream and wetland credits going forward. And obviously, this is only half of the equation. The supply side does matter. And so most of these states, I would say, though, supply is getting tighter as we're seeing not only strong demand, but accelerating demand for both credit types out there. So last, recognizing we've got a pretty Virginia-centric audience here, wanted to just give a little bit of context on what we're seeing within the state. And so no surprise, but we've, based on some of that data center development moving out of Northern Virginia as it started to kind of trickle out into some areas where there might be more land availability, we're seeing challenges in securing wetland crediting in both the Middle James around Richmond and down towards North Carolina in the Roanoke. In those cases, most of the impacts are stream impacts, but just due to a lack of wetland, of restorable wetland acreage, there's just been a shortage of wetland crediting. We expect that to be more of a near-term issue, and we do see some more inventory coming online sooner. But just kind of in the near and medium term, we've seen that being a strain on getting projects approved and securing their mitigation. Potomac remains, as I think it's been for the last 25 years, a pretty high demand market. Based on some of the analysis we've done, it could be considered the largest mitigation watershed market in the country, depending on what metrics you're using. So that's always going to be a source of potential strain and challenge in finding credits. As of now, it's pretty well supplied in the Potomac for wetland credits. Stream supply is low, but similarly, the Middle James, we expect that to be picking up as both Davey Mitigation and other providers up there are bringing more inventory online in the next couple of years. Lastly, on the nutrient crediting side, the York has been a pretty challenging place to secure credits, and that seems like a more persistent issue. We're working on trying to bring inventory online there ourselves, but that's been so persistent that we've seen credit prices in the doubling and tripling at times in that watershed. And so particularly if you have nutrient credit needs in the York, that's going to be a challenging place to develop projects. So the last two kind of plugs to give to just kind of reiterate some of the points made previously. If you look on the DEQ website in the York, you will see that there is inventory for phosphorus, and some of those are either outdated or reserved credits. And so again, making sure that you're validating some of the information you're seeing online is essential. And then if you do suspect that that the credit inventory isn't there and a PRM is a preferred option, engaging early on and trying to find your mitigation site is key to making sure the project's going to stay on track. I'm pleased to know that Sarah will be going after me and can speak to some of the things DEQ is working on that can ease both of those issues. And so excited to hear more about that, and I think would be welcomed news for everyone else. But I think that's all I wanted to cover for today. So pass it back to you, Christie.
Thank you, David. I was going to ask you about the new pine plantation guidance. I don't want to be duplicative if Sarah covers it, but if you have just a couple minutes to either kind of hit on that or the improvements that we've seen from the DEQ and core MOA.
I might let Sarah
Okay.
cover that.
Sarah, welcome. I will let you share your slide deck.
Thank you. I appreciate that. Can you hear me okay?
Yep, we got you.
You see my slides?
Looking good.
All right. Thank you. David's presentation is a great lead up to my presentation. I really appreciate that. And we didn't even plan it. But kudos to Davey for planning us in this order. It works very well. So I'm here from the Office of Permitting Assistance. My name is Sarah Woodford. You all know me. I have been a mitigation specialist in DEQ for a number of years now, and I'm here to give some mitigation and OPA program updates. Like that. There we go. So heading right in, because I've got a lot to cover. I'm going to go right into the mitigation and nutrient banking team. So this is a newly formed team within the Office of Permitting Assistance. Previously, the staff on this team were from the Virginia Water Protection Permit Program area under Brenda. We've been moved under Dave Davis in the Office of Permitting Assistance. This is a very cool new team. It's meant to really come together and provides, hopefully over time, provide some efficiencies two banking programs that are very similar. So you'll see staff from the non-point source program, nutrient trading program, as well as mitigation on this team. We did backfill the second mitigation specialist position, so we're glad to have Mindy Spence on the team now. She was previously a VDOT permit writer here in central office in Richmond, and she will be coming on to, she has come onto the mitigation team. So we, on the Office of Permitting Assistance, we also have, of course, the Ombudsman program, and we've created a position and just did a public announcement for the position for the Wetland and Stream Replacement Fund, which is DEQ's in lieu fee program, and we will have a coordinator for that program soon. So that is the entire Office of Permitting Assistance. I'm going to go in now into some banking team and mitigation updates. I can get the slides to go. There we go. So as I was creating this presentation, it was pretty easy because we've got some other public updates coming up. So for third-party mitigation, David's presentation hit on a current trend and an existing trend that was outlined for us first in a DEQ report that was given to the General Assembly in 2022. We first started seeing, and really the citizens of the Commonwealth started seeing this issue with supply and demand for mitigation credits. And so they had us convene a work group, and the end result of that was a report back to the General Assembly. And it identified a lot of the things that that David talked about. And it also identified outcomes that were proposed by this work group. So a lot of these are on this slide. But going first into review process efficiencies for third-party mitigation. So as Kim mentioned earlier, the mitigation team for Norfolk District has been reestablished, which is excellent. And DEQ is excited to work with the new members of that mitigation team. And some of the efficiencies that I've seen over the last year as Norfolk District has transitioned over to that new team are that IRT meetings are not currently being required. So you don't have to get through that IRT meeting or pre-application step before you go to a prospectus. So that's an efficiency for experienced mitigation sponsors for mitigation banking review. The Norfolk District mitigation team is really focusing right now on going back to the final mitigation rule. The idea of that optional draft prospectus, which is labeled as that phase 1 in the final mitigation rule timeline. And so you can do an optional draft prospectus, or you can submit a complete prospectus, and that could be the first time that the IRT sees this. So that's cool. That's been creating some efficiencies and some reduction of time for Army Corps staff. We're also seeing that, and you may be seeing with you or your clients, this idea of a streamlined IRT coordination. And what I mean by that is that the Army Corps reps, when the IRT comments on specific deliverables, say a complete prospectus, they are delivering the comments right back to the prospective sponsor and their agents. And they are then directing them to work directly with the IRT agencies who have commented to resolve those comments. And that is providing some efficiencies for the Army Corps. We did, David alluded to it and Christie did as well. We revised the memorandum of agreement between the Corps Norfolk District and DEQ in September of 2025. And that really cemented into place in the MOA the idea of meeting that 45-day timeline for a credit release if no site visit is requested. So that is in place. I do have a bullet for the Pine Plantation memo, but I'm not going to say much about it right now other than it was published, and we have a question and answer document that is in development right now. We've gotten a lot of good questions about the memo. And so we really wanted to put out a Q&A for everybody to digest. So that's coming soon. When you look at the report on supply and demand for credits, mitigation credits, there are several other things outcomes that we have delivered in the past year. DEQ and the Corps increased the stream and wetland mitigation program. So that's formerly VARDF, the Nature Conservancy's in lieu fee program. We increased the advanced credits for that program in March of 2026. And one thing importantly, we're talking at the federal level about getting comments back on how to provide more efficient review processes. The Corps and DEQ are rescheduled the listening session that was supposed to be last fall for third-party mitigation. That has been rescheduled for July 7th of this year. So if you're already on that list and you're getting emails from Jennifer Seraphin and the Army Corps mitigation team that are organizing that, that will be time to hear more about these initiatives that I just talked about, and also to make comments on the future of the third-party mitigation program in Virginia. We would love to hear your comments. So the two things I'm going to talk about mostly today are the Stream and Wetland and Nutrient Credit Exchange, which launched in October of 2025, and the Wetland and Stream Replacement Fund, which is DEQ's in lieu fee program, which was approved by the Corps in February of this year. So what's SWAN? If you've been on SWAN, this is a little duplicative for you, but if you haven't, I'm going to show kind of what I'm going to give a couple of screenshots of what it looks like. So it's a digital marketplace platform where mitigation and nutrient credit offers can be browsed, compared, and reserved. It was developed by Water Ledger in partnership with DEQ. Some initial challenges that we faced going into determining the supply and demand of mitigation credits, especially in Virginia, was this idea of data issues. A lot of the issues with determining that were data related. You know, we all know in rivets you can't reserve credits. We have these offline and sort of manual processes of permitting that are sort of causing delays. There's difficulty tracking compliance among those systems. And there's no central marketplace for price discovery, which is, our director Rolban likes to say that, that's a hallmark of a free market system, is having a public pricing system. There was also just this general lack of transparency between applicants and permittees and the regulated public regarding pricing, regarding the availability of credits. So SWAN was developed in order to provide transparency, consistency, and efficiency in those realms and solve this sort of lack of market information. So this is what it actually looks like. If you log on to SWAN, you can see everyone can see a market credit summary. Credits, you can see the total credits available for sale in Virginia. You can see the outstanding permits required credits. And you can see this sort of market index ratio that is novel to this platform. If it's under 1, that means that there's more demand than credit supply. And if it's over 1, that means there's more supply than demand. So you can, and you can hone in on the type of credit and the watershed and see in your neck of the woods what the outlook looks like. There are different market analytics dashboards for permittees and bankers. For bankers, it shows all of your banks in one wallet, and it helps you find open trade opportunities in the area. You can filter and export data, and you can generate reports on the platform. For permittees, there's a summary page with the credit requirement for each of your permits, and it generates a list of available credits per permit in order of the regulatory hierarchy. As you all know, in Virginia, the regulatory hierarchy requirement for mitigation banks first, in lieu fee program second, that's all built into the platform. There's also mapping tools on the platform. So for bankers and permittees, it displays, you know, basically the inverse. For bankers, it displays active unfulfilled permits in the bank's service area. And for permittees, it displays available credits within a service area to cover your project. So now that it's launched, we're hoping that this will provide, you know, different benefits for both bankers and permittees, as well as the regulated public. For bankers, it can help forecast that credit demand to hopefully prevent credit shortages in the future, like what David was talking about. You might be able to expand your client base if you're interested in doing that, and you might be able to find average market prices per watershed, which might help you to price out future mitigation banking projects. For permittees, you can get help forecasting the credit supply in the watersheds where you have projects upcoming. You might be able to find available credits easier than the current tools. You have that built-in regulatory compliance, which means that you can rest assured that the option you're choosing will probably be the best option within the hierarchy. And you got that transparent pricing. While we didn't think about it as we were developing the platform with Water Ledger, there are some benefits for regulators and therefore for the regulated, for the public and their interests that are realized on the platform. For instance, it helped us identify and correct innumerable data errors from contact information to credit ledgers. We're getting less calls on the mitigation team in central office for DEQ. Asking for, you know, where can I find credits? Because there is another tool available to help assist them with that. It can reduce permitting delays and help you provide more timely mitigation for your projects. It also provides standard documentation. Right now it's in PDF form, so you can print out a credit reservation or a bill of sale from the platform, and you can turn it in as your compensation plan. But we're hoping that in the future to potentially automate delivery of that to permit writers from the platform. Okay, on resources. So if you haven't been on the platform yet, here's a QR code with the link to Stream Wetland and Nutrient Credit Exchange. All right, so I'm moving quickly into the Wetland and Stream Replacement Fund, that's WSRF, which is DEQ's in lieu fee program that was approved by the Army Corps in February of this year. So, like I said earlier, we have a program coordinator position for the in lieu fee that we are hiring for right now. I believe that the application period just closed for that, so Dave will be going into interviews for that soon. So when that position gets hired, they will be coordinating all aspects of this program. And so you'll be coordinating with them on certain questions, such as, these are the basics of the program. Can I purchase credits from the WSRF? So credits for this program it's written into the WSRF program instrument that it can be used for active permits, for applications, for court orders, or some other regulatory purpose. So we're really not getting into non-regulatory purposes. And it can be used only if no mitigation bank or other in lieu fee credits are available in the watershed to serve your project. How do I search for available credits? I went over some of those already. So you can go on the SWAN platform to search for available credits. You can use Ribbit's Find Credits tool. You can even use DEQ's Permitting Enhancement and Evaluation platform to search for upcoming credit releases. How many advanced credits are available? So credit availability is written here per watershed. You'll see that for higher demand watersheds like the Potomac and the James River, we felt it was appropriate to ask for, and we did get approved, more non-tidal wetland credits and stream credits. For other watersheds, it's scaled down just depending on what the potential demand was going to be in the watershed. And what everybody's probably been waiting for, how do I purchase credits? So you can visit the WSRF website. I'll have a QR code in the next slide. We're going to ask you to fill out what's called a credit eligibility checklist for your project, and turn it into the appropriate staff. It's going to be the in lieu fee coordinator, but right now it's a different email address. And on SWAN, if you're on SWAN, you can submit a request to reserve WSRF credits right on that platform. All right, so we've got some resources here. For more resources, you can grab that web page. It talks about how you purchase credits. You can go and get the credit eligibility checklist. You can look up what the price is in the watershed of your project. All of that information is on this website. All right, last but not least, DEQ's Ombudsman Program. So the Office of Permitting Assistance was originally created to house this Ombudsman program. You might have worked with these folks already on economic development projects, and they are still here and available within OPA. Permitting ombudsman roles include assisting with economic development projects, navigating the environmental permitting for economic development projects. They also can help identify potential environmental and cultural resource concerns ahead of permit applications. They serve as a liaison between permit applicants and DEQ technical staff in the regional offices. And they collaborate closely with VEDP, the Virginia Business Ready Sites Program, and local economic and industrial development offices. These three folks are your Office of Permitting Assistance Ombudsman contacts. So Dave is among them, Tanya Pettis and Tim Wilkie. There's a lot of good information on the Office of Permitting Assistance website, including permitting keys, a permitting guide for economic development projects, things like that. So I would really recommend going to the website here as well. They have assigned regions which follow the VWP and DEQ regional office regions. So they're assigned to their own regions. And here we go. So you've got the website here for environmental permitting guide for economic development in Virginia and the permitting key. All right, thank you.
Awesome. Thank you, Sarah. Appreciate it. All right, let me share my screen. So next up, we have our rapid fire environmental regulation roundtable. So I am going to ask all of those whose faces are on the screen if they could turn their cameras on. We have a handful of folks from our Davey Resource Group and Wetland Studies and Solutions offices to give you all kind of a nationwide, if you will, update on some pertinent regulatory changes. And then we've invited Justin Curtis back to give his legal perspective on what we've got to say today, or just generally heckle us. We'll see what happens. So today we're going to start with Sue Quackenbush from our Davey Resource Group New Jersey office and Haley Kelly from our Wetland Studies Maryland office. So I'll let you guys take it away for the Northeast region.
Hi, good afternoon. Thanks, Christie. I'm Sue Quackenbush with Davey Resource Group out of Flemington, New Jersey. And I'll just jump right in, and starting with New Jersey, this past January, we had a pretty sweeping regulatory adoption here in the state of New Jersey called Resilient Environment and Landscapes. These changes were the most significant change to our land use regulations that we've had in decades. And they were formally adopted in January of 2026. One example of the sweeping changes they made was increasing our tidal flood elevations to the FEMA base flood elevation plus 4 feet is now regulated by the state of New Jersey. A new update just recently happening is that there are 2 bills on the floor to repeal these, one in the Senate, one in the Assembly. And the point of the repeal is really saying that when the acts were written, they could not have intended to address climate change because the acts have not been updated in over 40 years. And therefore, this rule adoption is beyond the intent and the scope of the original act. So more to come on that. Also in New Jersey, our new governor has launched within our New Jersey DEP Operation FAST, which is an acronym for Facilitated Approvals for Sustainable Transformation. Following in the footsteps of some other states, this is intended to bring faster, more efficient permit reviews, specifically for clean energy infrastructure projects. Moving on to New York, in January of 2025, the state of New York made some significant changes to their Freshwater Wetland Protection Act, which Justin touched on earlier. It brought into regulation a lot more area of freshwater wetlands, whereas previously the state had only taken jurisdiction over wetlands that were 12.4 acres or larger. Those rules have been annulled. They were annulled on the 8th of April in 2026. The premise of that annulment is that the rulemaking did not properly follow SECRA, which is the State Environmental Quality Review Act. So having not followed SECRA, those rules are currently in annulment, which resulted in a bit of a regulatory gap for a while. But just this week, the state has issued a procedure for at least advancing pending JDs. Again, more to come on that moving forward. We'll see how that plays out in New York. The current guidance we get from DEC is waiting for guidance from Albany. So we'll see how that plays out as we move forward. And then moving into Pennsylvania, overall permitting in Pennsylvania has really improved. There's a lot more regulatory certainty and a lot faster and expedited permitting in Pennsylvania, primarily due to the permit fast track program that was implemented back in 2024. An interesting development there is that the Governor Shapiro, has been talking more and more about the GRID program, which again is an acronym for the Governor's Responsible Infrastructure Development Standards. Now this applies to large infrastructure projects, but primarily in the news, you'll hear about it in the context of data centers. A lot of data center development going on in the state of Pennsylvania. And this initiative is intended to incentivize data center developers to go above and beyond what's regulatorily required by providing more significant ecological uplift to their states, and also taking on some added responsibility when it comes to the power grid and power generation and power requirements required for these big infrastructure projects. So the GRID program is incentivizing inclusion in the fast track program for developers of these projects that can go above and beyond. Also in Pennsylvania and New York, the U.S. Fish and Wildlife adopted, or well, actually became effective this January 15th, the multi-bat species general conservation plan. And this plan applies in the states of New York, Pennsylvania, as well as West Virginia. And this is The general conservation plan is really a pre-approved set of conditions that allow for more streamlined U.S. Fish and Wildlife review of listed bat species requirements when developing certain types of projects, of course, with certain limitations and requirements. So that's it for my part. I'll pass it over to Haley.
Thanks, sir.
All right, I'm Haley Kelly with the Maryland office, Senior Environmental Scientist and the Senior Regulatory Specialist. Maryland has been notorious for not changing their regulations for like decades, since the early 90s, but there are a lot of big changes coming up this year. First up is forest conservation. They are generally changing to a 1-to-1 mitigation requirement. So for every 1 acre of forest clearing, you're required to plant back 1 acre. They are focusing mostly on new plantings and trying to limit the amount of retention credits available. So this, like, typically in Maryland will depend on the counties. There are some state regulations, but counties are rolling out new forest conservation manuals. So please check in on those. They are also requiring that all stream buffers on the project site must be reforested regardless of your mitigation needs. Those changes are coming into effect on July 1st of this year. So if you do not have a forest conservation plan in the works, you need to get started on that. The other big change is the Tier 2 high quality waters review. This has been on the books for a while, but it's becoming a lot more intense recently. Maryland is trying to gather some of the environmental justice efforts that have kind of dropped off on the federal level and incorporate them through this process. It is separate from wetlands and waterways permitting and is required to get your NPDES permit. So you should be starting this process very early in the permitting phase, because this can be a year-long process. This is looking at impacts to streams, 100-foot stream buffers, forests, and increases in impervious surface. It will require mitigation. There is no fee in lieu program for this, and mitigation must be in the same watershed. For some of these small watersheds in Maryland, this is a huge deal. Any forest mitigation required for this is above and beyond your county requirements. So for some developments, this could be doubling or tripling the amount of reforestation you're required to do. The next big change is in wetland mitigation. David touched on some of this earlier. Maryland is trying to align their standards with federal standards so that we can have a fee in lieu program that's recognized by the Corps of Engineers once more. We're also incorporating environmental justice into this effort to try and capture that. We're looking at more rigorous financial assurances, stricter timing at when mitigation has to occur in relation to when those impacts are being taken. There's going to be updated monitoring and performance standards to ensure that you're meeting those requirements and creating high quality wetlands and waterways. They're also shifting to a functional quality-based method of evaluation. So if you are looking for mitigation, if you have a bad wetland, low quality wetland, the credits that you're going to be required to purchase are going to be lower than if you're impacting a higher quality wetland. So that could help some projects, could hurt others. And then they're trying to update their bank approval process to be more streamlined. We will see about that. I was not super thrilled with the requirements. They just put them out for comment. So we'll see how those change before they get to the final process. And then just some other more administrative updates. Maryland has finally initiated an online permit application process. So we're no longer mailing 7 paper copies anywhere. It is an online, I know it's a big deal.
Big news.
We are no longer mailing things. We are doing it online, which is very easy drag and drop system. The payment must be completed online at the time of submittal. So we're no longer mailing paper checks to a random mailbox. It has been a much smoother process. We do not have the RSS system here in Maryland through the Corps of Engineers. However, they are asking that JD applications now start to go through the RSS portal. The other slight update is that Maryland has updated their fees finally. Last year was the first year they updated them since the 90s. So JPAs went up from $750 to $980. However, now they are adjusting everything for inflation. So starting July 17th, you will see an increase of between $2 and $5 on all your permit applications, including your modifications and any transfers. So
Awesome.
that's all we got.
Thanks, Kelly. Save the trees. Kevin, updates from you for our southern region?
I mean, in the Carolinas, we're pretty much, there is some small nuances depending on counties you're in and if there's buffer requirements, but as far as WOTUS goes, it's in line with what myself and Justin were talking about earlier. I mean, in North Carolina, the Environmental Management Commission, you know, in the previous administration ruled that if it's not federally jurisdictional, it's not state jurisdictional. South Carolina is very similar. Georgia, same. I will say South Carolina, North Carolina, Georgia, some are pre-2015 rules, some post-Sackett. I do know in the Charleston district, they still try to utilize the Strawler method when doing streams and have been known to go further up into reaches that are non-jurisdictional to try to take jurisdiction over wetlands. So there are some slight nuances. There was a recent Mobile district meeting where I know an Army Corps chief was asked directly if you're going to continue to utilize that method even after 2025 rule, and I believe it was answered as yes, we are. So there are some slight differences in that case, and just to be clear, I'm not going to touch Florida. I'll let Justin, if he wants to go into Florida. I've worked in Florida. We usually delineate 3 lines there, core line, state line, and water district line. So that's a whole nother beast down there. But for the most part, I would say in the Southeast, with the exception of Florida, if it's typically not federally jurisdictional, the state typically won't go after it. Now, of course, Tennessee, we understand, you know, they will take waters that do go subterranean, and in that situation, it would be state waters only. They do protect isolated systems. So there's just so much to cover just in the Southeast, but we do have a lot of teams in a lot of different states. And a lot of times when I have clients that call me, because we have national clients, I will immediately begin talking to those area managers in those states, because it is very difficult to keep up with.
Yeah. Before we hit the Midwest, Justin, any thoughts?
No, I think everyone's covered everything pretty well. I've got nothing to add.
Okay. All right. Heather, Midwest updates? You're on mute, Heather.
Sorry about that. Hi, I'm going to be touching on 5, 6 different states, so I'm going to kind of keep it high level. But so I'm looking at Minnesota, Wisconsin, Michigan, Illinois, Indiana, and Ohio. Any state that touches Lake Michigan, Ohio is over on Lake Erie. But in general, the way that the federal jurisdiction is working in all of these states, except for Indiana and Ohio, is they are using the post-Sackett interpretation. So if you don't have that continuous water connection, the feds are not taking jurisdiction of it. In Indiana and Ohio, the best thing I can come up with is that it's kind of on a case-by-case basis. I've been meeting with, it's supposed to be back to the 2015, consistent with Sackett, and one of the core project managers I was meeting with on site last week in Indiana, he said if he doesn't see that surface connection, he's not taking it. So, you know, it's not officially post-Sackett, but it seems to be kind of how it's being interpreted. So what that means is in all of these states, we're going to have fewer wetlands and streams being regulated at the federal level. And we are in a weird kind of cluster of the country that has a cluster of states that have pretty robust isolated wetland policies in place on some level or in the works. Minnesota and Wisconsin, they have pretty robust non-federal wetland regulatory programs that require mitigation. They concurrently came up with a new rapid assessment methodology that is supposed to be able to, kind of help you get more details on what your impacts are going to be and help you frame out your mitigation. We've been through that rapid assessment methodology a few times. It's not rapid. It's quite in depth. And Illinois, right now they do not have a specific isolated wetlands regulatory program. They do have a couple of existing state protections. One is the Interagency's Wetlands Policy of 1989, and it regulates any state-funded construction projects that cost more than $10,000. So they will regulate wetlands in those situations. They also have a strict no net loss policy for wetlands impacted by state projects. And then there's the Rivers, Lakes, and Streams Act, which provides the Illinois DNR authority to regulate construction activities in 100-year floodplains. So that's where wetlands might get regulated in those situations. In addition, there's proposed legislation in Illinois. It's called the Wetlands Protection Act, and it will essentially create an isolated wetlands regulatory program in Illinois that, reading through it, it kind of closely aligns with what Indiana does. It classifies wetlands by their quality, and then mitigation requirements follow from there. The bill passed the Environment and Energy Committee in April, and what I was reading is that they were going to try to vote on it before they closed session on May 31st, but now what I'm seeing is that they are going to try to vote for it in a November veto session. So ideally, at the end of the year, we know if Illinois is going to have isolated wetland protections. In Indiana, we've had isolated wetland protections in place for a very long time. And over the past 5 or 6 years, certain things have happened to kind of chip away at those protections. There are exemptions that have been increased. They took any wetlands in agricultural fields, as long as they're a certain low quality type, they are now exempt from permitting. So the amount of wetland regulation in Indiana has decreased slightly. I haven't seen a huge impact on the mitigation market as a result in Indiana. Indiana also has an in lieu fee program that has been kind of interesting watching it grow. It started in May in 2018. And they're struggling to get a lot of projects on the ground, and a lot of the service areas for in lieu fee market have run out of credits. So now the in lieu fee program is starting to buy credits from banks, which is great for mitigation bankers. And then, so, that mitigation banking rule, the hierarchy is the bank, and then the in lieu fee, and then PRM. And some of these larger developer clients that we're working with are now starting to do more PRM as well. Because they have the capacity to build large projects and make them ecologically sound. What other state? Michigan. Michigan has also had a pretty robust isolated wetland regulatory program for quite a while. If the feds do not take jurisdiction of Michigan, the EAGLE program in Michigan, which is the Michigan Department of Environment, Great Lakes and Energy, they call it EAGLE. They will regulate wetlands that are greater than 5 acres in size. And then there are some also local and county level regulations that are different everywhere that can be more strict than that. In Ohio also has an isolated wetland program. They, over the last few years, took ephemeral streams out of jurisdiction. So when the federal agencies stopped regulating ephemeral streams, Ohio also switched their regulations to not cover ephemeral streams. So pretty much in Indiana and Ohio, we don't have much in the way of headwater stream protections any longer. Let me see if there's anything else I need to touch on. That's about it.
Awesome. Thank you, Heather. Appreciate that. Justin, any final thoughts? from your perspective?
Yeah, no, happy to answer any questions, but I mean, I think the panel covered everything very well. I had nothing to add.
Great. Awesome. Well, I appreciate all of you guys kind of jumping on for rapid fire session. We do have one more set of speakers that I will introduce next. We have Melanie and Victoria that are joining us to give the couple more Virginia updates and also talk about environmental justice in the state. So let me share my screen. There we go. Melanie, take it away.
Hi, everybody. Nice to see you. For those of you who know me, I have been into EQ a really long time. My latest position has been the director of the Division of Cross Media Programs, which includes everything from enforcement to environmental justice, and a host of things in between. I am slowly preparing for retirement. So today I'm really excited to introduce Victoria De La Casas, who joined DEQ about 2 weeks ago, and she is the new director of the Division of Cross Media Programs. And I thought this was a great opportunity for her to join us on this webinar and introduce her to folks. She's going to be focusing for her first few months on environmental justice, tribal consultation. I'm going to keep my hand involved in enforcement and communications, and managing our litigation. But I just thought it was a great opportunity for you all to meet Victoria. And she's going to go through a very, very fast track project that we currently have going on about environmental justice. But before I turn it over to Victoria, I did note that one of the items that was suggested on the agenda from DEQ is an update on legislative actions. There's really two things I wanted to bring to the attention of this group. The first is House Bill 950, which will actually find its way into Code Section 19.2, 60.1, which is a piece of legislation. It's a section in the code that limits the use of unmanned aircraft systems, specifically drones. What House Bill 950 did during the last session is it authorizes DEQ to actually use drones as a compliance tool. What's interesting about this bill is that the authorization is for implementation and civil enforcement. It is not authorized for any criminal enforcement. And it is specific for those permits and programs that are spelled out under our Virginia Water Protection Permit Program and the Stormwater and Erosion and Sediment Control Program. So for those of you that might know Mike Rolban, this was an initiative that he really worked on, wanted us to have this ability. And what our plan is to have drones for use on bigger sites, such as several thousand acre solar farms or many mile pipeline projects. And we're just going to use them as a tool to cover more ground airily, by air, I guess is the right word. And then that will let us and our inspectors target where they need to go. We just spend, as you might imagine, a huge amount of time driving and hiking on these big projects. And the idea was that the use of drones, and they're going to be very simple drones that, we're not talking about $50,000 expensive, really cool things. It's really just for visual sighting of places where we may need to follow up in person to take a look at either possible noncompliance or possible violations. Just to remind folks, the new legislation doesn't kick in until July 1st. I don't know that we've actually purchased the drones yet. We do have a work group kind of specking out what kind of drones we need. We apparently do have a few folks on staff who actually are licensed drone operators. So again, a compliance tool to direct us to where we need to go in person to take a look at situations on the ground. The other bill I wanted to mention is House Bill 1350, which hopefully none of you or none of your clients will ever need to touch. And this is a bill, well, let's see. If someone violates a permit, our first resolution is always going to be to try and reach a consensual resolution with an agreed upon penalty and agreed upon corrective action. If, however, we are not able to get to that point of a consensual agreement, we have the authority to bring someone in for a hearing where we will, it's an informal fact finding. We will establish the fact of the violation. We will determine what the corrective action is, and we can assess a unilateral penalty. Since the time we were given that authority until just July 1st of this year, that unilateral penalty has been capped at $10,000. House Bill 1350 bumps that up to a cap of $32,500, which means we now have a tool that we can use to order somebody to get back into compliance and pay an appropriate penalty. Again, a fun fact about these particular kinds of unilateral orders is that the director of DEQ is the only entity who has authorized to issue those orders. And again, if you and your clients, comply with the regs and don't get into enforcement trouble, it's not something that's going to potentially impact you. But we do have violators who are not able to reach a consensus with us. So this is a tool that will allow us to move those cases forward more quickly. And then the other thing too is there's a provision also in this bill that bumps up a penalty, the maximum penalty that a locality that operates only an erosion and sediment control program, they had been capped at a civil penalty of $1,000, and that was also bumped up to $32,500. So just a couple things. Again, if y'all comply and if your clients comply, you don't have to worry about either of those. And with that, I'm going to turn it over to Victoria to talk about what's going on with environmental justice.
Perfect. Thank you so much, Melanie. Thank you for this introduction and good afternoon, everyone. And thank you for this opportunity to present to you today. So with just less than 2 weeks under my belt, my main and primary focus here was working on environmental justice guidance. And this is because of House Bill 1266, which was approved on April 8th, and it becomes the law on July 1st. But we already have a lot of things to do on this bill because of the very compressed deadlines, and I'll talk about them. So this bill was originally introduced by Delegate Katie Tran, and it looked very, very different in the beginning of the session. It was almost 3 pages long, as opposed to just one paragraph of how the bill looks right now. And it included a lot of public participation requirements for applicants of certain permits that are issued by DEQ. It included a specific list of those permits. It required applicant to conduct a public hearing notice, a public hearing. It required DEQ to conduct public hearing. It required applicant to submit mitigation plan in case of adverse impacts to communities, and gave DEQ the authority to deny the permit. This bill doesn't look like this right now. So right now, this bill requires 2 items. Well, first of all, DEQ must update its existing draft environmental justice guidance. Some of you may remember that back in 2023, DEQ issued the environmental justice in the permitting guidance, which applied to certain types of permits that DEQ issues. That guidance was issued for public comment. Public comment was taken, but it was never finalized. So it can be found on DEQ's website as a draft guidance. So this House Bill 1266 now requires the agency to issue a revised guidance. And this revised guidance should include 2 items. First, DEQ in the guidance shall consider strategies to engage impacted communities. And here we are talking about meaningful involvement concept that can be found in the Virginia Environmental Justice Act. And second requirement is that this updated guidance should consider how to assess cumulative impacts of projects that are covered in the guidance. And here we are talking about the fair treatment concept that can be found in the Virginia Environmental Justice Act. Christie, if you could advance to the next slide, please. Thank you. And so a significant part of this House Bill 1266 is that it imposes what think are very compressed timelines on the agency to issue the revised guidance. So one of the deadlines after DEQ is going to issue a proposed draft and open it for public comment will be to hold 2 public town hall meetings. And that has to be done by July 31st of this year. So in a little over than 2 months. After the public period closes and we collect public comments, then the bill requires that DEQ responds to public comments by October 31st of this year. And then the final requirement is that DEQ will have to issue a final guidance memo by the end of this year, by December 31st. And so some of the things that are not defined in this legislation are, first of all, what are the public town halls? This term is not defined. And the second aspect that is not defined is what are cumulative impacts, or how to assess cumulative impacts. And that is a part of what we are working right now in revising our existing guidance. And since the new guidance will have to piggyback on the 2023 guidance as required by the bill, I just wanted to briefly remind everyone about what that guidance was about. And again, you can find it on the, that's okay, you can put our contact information. You can find it on DEQ's website, but essentially it required that the guidance apply to permits of concern, and the guidance included a list of those permits for air, for land or waste, and for water. And then it required 2 aspects. First, public participation. It required applicants to conduct public participation, and the guidance suggested a toolkit of how that public participation can be done. And the second aspect, it required additional analysis of potential disproportionate impact for the permits that are covered under the guidance. And so for air, it would be air modeling, and then for water and land, it will be proximity to landfills or proximity to impaired waters. And so we are using this document as a model, again, as directed by the House Bill 1266. We plan to post the draft soon by July 31st, and we'll be notifying you all about the public town halls. So we are looking forward to all of your comments on this topic, and I think we'll have time for questions. So happy to take those at the end. And here's our contact information. You know Melanie, and now you know me, so feel free to reach out.
Victoria, I do actually have a quick question for you.
Yeah.
Looking back, let's go and get back to the slide. So the final guidance memo you expect by the end of the year. What happens if we, and maybe you can't answer this, so that's fine, you can defer.
I'll try to. I'll tell you if I cannot.
But what happens if we submit, as an example, an individual permit application, which otherwise would need to adhere to this guidance, and we submit in January? You know, are we retroactively going to need to address what's in the memo, or do you have any sense of what that might look like?
That is a wonderful question, and we are working on addressing it in the guidance. Okay. Because I understand that sunset provisions may be very important, especially for the new system that may not be known. So we will include, if there is any sunset provision, this will be in the draft guidance that again, we're very actively working on now
Yeah.
and expect to post very soon. So
Okay.
look for it in the text.
Okay, excellent. And my last quick question, you had mentioned a toolkit for the public participation. Was that was based on the previous guidance? Is that on your all's website?
It was included in the previous guidance as several suggested means how to engage communities. This topic will also be addressed in our guidance, right? Because one of the aspects is strategies on how to outreach communities. So you see it in the guidance too. But I believe that our DQ website, and Melanie may be able to speak to that, has some information on the suggested outreach strategies. Again, subject to check.
Sure. Okay, great. Did you want to add anything to that,
Melanie,
You're on...
I think you're on mute.
Yeah.
I just want to say that I know that project developers don't like the gray area, but what we have been doing in terms of environmental justice outreach during this time when we had proposed guidance, but it was never acted on, it was never finalized. We do a case-by-case analysis. So to the extent that we know about projects where we believe outreach is necessary, is appropriate, we will start working with an applicant and say, hey, you know, either we know something about the community or we just have reason to know that a project is going to be controversial and will have an EJ aspect. We on a case-by-case basis, we work and say, okay, what do we have to do? What do we think an applicant should do? You know, we actually have some large corporate permittees who basically run and do a whole EJ outreach and analysis on their own, right? They keep us involved. We know what's going on. There is and has been a lot of uncertainty about what the EJ Act means, about what kinds of clear obligations it puts on everybody. For those of you who may or may not know, we recently issued a permit to the Dominion Chesterfield Energy Reliability Center, which has been appealed. And one of the issues there is the question of EJ and EJ outreach. So, you know, at some point as that case unfolds, we may learn some more as at least to what the Richmond Circuit Court thinks is appropriate to comply with the 2020 EJ Act. But it is a gray area. It's been a gray area since the bill was passed. And I know it's really hard, but that's one of the reasons we're pushing to get this permitting guidance out there, is to put a framework around it. So
yeah, no, I appreciate that. And that one more question for you. And again, I realize it's difficult to answer now. So we'll have to do another one of these at the end of the year when all that comes out. Do you have any sense of will there or could there be changes to the public comment process if there's a project in an EJ community, like as an example during the public notice for an individual permit? Or is this all engagement in advance of that?
I think there could be suggestions on additional actions to be taken during the permitting process, realizing that this is a guidance document, right? And
yeah,
what we can do for now is recommend and suggest.
Yeah, okay. That's fair.
I hope that was a satisfying answer.
No, I appreciate it. I know it's hard to even take questions at this point, but I appreciate your time. I am going to kind of open it up for the whole group. I'm going to stop sharing. There's our QR code again to get back to our website for this information. I'm going to stop sharing, and if the other folks on the call, our other panelists, don't mind putting their cameras on. We have several questions in the Q&A right now, so I doubt we're going to get to everything, but I've got a couple in front of me that I wanted to ask. Let's see, I'll start with, I think, Kim, not to put you on the spot, but that's what I'm doing. Question here from Adam Grokel. Will there be a permit tracker for applications submitted through RRS similar to what DEQ has on the PEEP platform?
So yes, there are plans to continue expanding RRS, and PEEP has been actually talked about at the headquarters level as a model for how to do that. For sure, they are planning to implement milestones. So once the project manager on our end enters that, for example, ESA consultation is needed, that milestone would be visible on the dashboard with a start date and then, anticipated dates. They are working on right now really more of a project manager dashboard on our end, which I think will facilitate that coming through on the dashboard side. So more to come, but there are plans to do something along those lines.
Okay, great. Another quick question for you, Kim, from Stephen Morse. Do you expect, will there be future RRS trainings to go over other recent updates?
We didn't have plans for any, but if there's an appetite for that, we certainly can start planning that. We were kind of waiting to see what the no PCN required module would look like.
Yeah.
Now that that's out, though, I think we could probably go ahead and try to set up some dates. So I'll look at doing that.
Okay, great. Let me see here. Sarah, I saw you pop up, and perhaps a question for you or Brenda. Do you mind touching base a little bit or giving us an update on DEQ's phased mitigation? Or we'll just make Justin answer it. That'll be the default.
Do you want me to jump in?
Go ahead.
Yeah, it's my understanding, and Brendan and Sarah, of course, correct me, but phase mitigation has always been allowed for individual permits, and as a function of guidance in the VWP permit manual, phase mitigation was not allowed for VWP general permits. And my understanding is there was a change either pending or that's been completed that would eliminate that restriction on phase mitigation for VWP general permits, which is, that was could be critically important for certain types of projects when, if you in the event you have mitigation shortages or you have a credit availability letter and you get to the end of the process and those credits aren't there, or maybe not enough credits are there. With the WSRF, that may be less of an issue going forward, but my understanding is there is additional flexibility, at least in the guidance, again, subject to Brenda or Sarah correcting me.
No, you're right,
Yeah,
Justin.
We jumped in at the same time.
We did. So that prohibition on the phase mitigation for general permits was in a guidance memo. The decision was to eventually rescind that guidance memo. So we are working on that currently. We have updated the VWP manual in the meantime to allow for phased mitigation for general permits.
Yeah, and that manual is on our wetlands webpage. There's a link you can click each chapter open and read about that. I think it's chapter 3.
Awesome. Thank you. Appreciate that. Maybe we'll throw this one to Justin too, but I'll open it up. Can you all speak to the challenges of varying interpretations between EPA regions and how they may or may not be remedied by the current rulemaking?
Is Kim still? Looks like we don't have Kim. Yeah, I'll just jump in with a quick 2 cents on that. I mean, we've got, the core obviously is going to primarily be implementing, assume we're talking about WOTUS, primarily implementing the rule on the ground. So, and as we all know, the Corps is a highly decentralized agency. And so you can get inconsistencies from district to district already, and even from project manager to project manager. So I think that's just a feature that's long predated WOTUS, this latest or upcoming WOTUS rule, and will continue into the future. Over time, as you get new cases, you'll get the new WOTUS rule, you get more litigation, you'll get cases, and stuff will start to be crystallized, but there will always be those marginal cases where you're going to get a different answer with a different project manager in a different district or a different EPA region.
Yeah.
Yeah, I would largely agree with that. I think the other thing that may complicate this as we move forward is even if we get a new rule, there's a very good likelihood it will be litigated. And we could be in this kind of patchwork framework again, where districts, depending on what litigation they're under, will be applying different rules. So we'll see what happens.
Yeah, so, with that and the unknown, and I think I know the answer, but I'll ask it. Kim and Brenda, with the new WOTUS rule, do you all expect more AJD requests and SSWD requests? And do you expect in that case to prioritize those requests? I know the JDs as an example were kind of deprioritized with regard to permits, but given where we are now, do you expect a change?
So yes, we do expect when the new rule comes out to see a lot of requests to revisit previous AJDs and provide new ones. We probably will not necessarily be changing our prioritization. Honestly, that prioritization is based on how we're funded. And we're just not funded for standalone JDs. Now, if that request for a new AJD also includes requests for no permit required, that does elevate the prioritization a little bit. So those will get slightly higher prioritization in that case.
And we are expecting to see more SSWD requests with whatever happens with WOTUS.
Yeah, okay, appreciate that. In cases where folks may already have a JD, how will the Corps regulate impacts to features that are covered by that prior JD with under the new WOTUS rule if some of those features may no longer meet the new WOTUS definition?
So in the case where somebody has a site that the jurisdiction changes due to the new rule, if they come in for new permitting, that's really the cleanest way to do it. Through the permit process, we can also go through and do that JD kind of on the informal side to determine what features would be jurisdictional under that current rule, and then do whatever permitting actions are needed from there. So doing it that way is the quickest way, most streamlined way to get a decision and a permit if needed.
Okay, great. Appreciate that. Let's see, we only have a couple minutes left. I'll just kind of open it up. Were there any other final thoughts that folks wanted to convey or felt like they didn't already address? Once, twice. Okay. Well, again, I really appreciate all of our speakers today. I know everybody's very busy. There's a lot going on, but we appreciate you guys taking the time to help convey this information to the masses. Again, this presentation has been recorded. The recording and all of the slides from our presentations today will be on the website. And those that joined us expect certificates in the coming days so we get our CEUs. Thank you again. Really appreciate everybody. Have a good day.
Thanks,
Thank you.
everybody. Bye.
Thank you.